Welcome to another episode of From Stuck to Limitless, the show where we bring you fire starters and change makers with tips and insights to uplevel your life from stuck to limitless. I am your host, Marie McKenzie, and this evening is no exception. We have another fabulous guest for you. Out of Florida, attorney Sonya Peterkin. And without any further ado, Sonya, take it over and tell our listeners who you are and a little bit about yourself.
Thank you. Well, thank you again for having me. You introduced me as Sonya Peterkin. I am an immigration attorney here in Central Florida. My practice is almost a decade old. We have been primarily focusing on immigration issues pertaining to family immigration, which consists of U.S. citizens and permanent residents sponsoring their family members to live here in the United States. We also assist people with deportation issues and applying for green cards and visas and all kinds of immigration issues that you can think of. So you will probably provide contact information a little later on. But yes, I'm so happy to be here today to talk about my practice and anything immigration related and how I got here today.
Thank you, thank you, thank you, and welcome. And before we move any further, what started you on the journey and to become an immigration attorney?
Yeah, so when I applied for law school, I already knew that I wanted to do immigration law. I actually started my law school career knowing what field I wanted to practice. And I think I was just led to immigration because it was the most familiar area of law. My family are immigrants from Jamaica, and I grew up in South Florida in a immigrant-based community. So, I was very familiar. I was a part of the community, and I felt like when you are able to relate to your clients because you kind of lived a lot of their experiences, you're able to provide a different level of representation. So it was just something that naturally came to me.
Awesome, awesome. Thank you. So tell us the typical process if you're migrating from the Caribbean. If you're thinking about it, you have a family member who lives in the United States and wants to file for you. What's the process, including how long it will probably take?
Yes. Okay. So actually, family-based immigration is one of the most popular types of immigration, especially spousal petitions. But if you are overseas and you are wanting to immigrate to the United States and you have a family member that's here in the US, the first step is for your family member to file a form I-130, which is a petition for alien relative. That form will be filed with USCIS and it will be accompanied with documentation that proves your relationship. So not all family members will be able to immigrate based on a petition filed by a family member. The family member must be a US citizen or permanent resident, and they have to be very closely related, such as a spouse, parent, child that is 21 years of age or older. I don't know if I mentioned parent, and even siblings. If your sibling is a US citizen, they could petition for you. However, that process takes a very long time for visas to become available. So the first step is the I-130 petition. That typically takes about 8 months or longer, really depends on the service center. And at the moment, processing times are very inconsistent. And so it's very hard to actually tell you how long your petitions will be pending. It could be like anywhere from 8 months to almost 2 years. And then after you receive an approval on your I-130, it's transferred over to the National Visa Center, which acts like a secretary to collect additional fees and forms and documentation. And once you have completed that part of the process, the NVC will finally transfer your case over to the embassy, who will schedule the interview and you will be able to attend your interview. If all goes well, you'll be approved for your green card and able to immigrate to the United States. So it is a multi-step process, and it typically takes about a year from beginning to end.
Thank you, thank you, thank you. What are some of the things that can place barriers? What are some of the barriers that some of these potential immigrants face?
Yes. Well, something that's common in the Caribbean community is issues with their documents, like birth certificates. That's pretty common, especially if it's a father applying for a child. They're not on the birth certificate, or maybe a name has been misspelt on the birth certificate. So that sometimes creates some barriers where we have to get that corrected, but a lot of times we are able to get it corrected. So just in case someone who may have like misspelled name or a missing parent on their birth certificate, there is hope that you can get it corrected and then proceed with your immigration. So that's one obstacle. Another obstacle could be that the petitioning family member does not earn the minimum income that's required to file for their family member. So if you're immigrating based on a petition from a family member, you have to prove that you're not going to become a public charge, which is someone who's going to become dependent on the government. So in order to do that, your petitioner, the petitioning family member, must complete a Form I-864 affidavit of support, and they have to prove that they have the minimum income. And another obstacle is that even if they do have the minimum income, sometimes there's difficulty proving it. That's a whole different story. Maybe they haven't filed taxes. They're going to have to file taxes because they need the tax documents to prove income. Or maybe they're self-employed and they don't really keep track of, their income well. And so that creates another barrier. But there are oftentimes when there are barriers, there are solutions for them. So we're talking about barriers, but we overcome those barriers that I just mentioned by getting a co-sponsor, or adding a household member's income, or using assets. So we're able to kind of work around it most times. I can't recall a time where that has just ended the process for a person who wants to immigrate that experiences those obstacles. So those are just a couple.
Okay, thank you. Another thing I want to explore, the difference between a fiancé visa and a marriage visa.
Yeah.
How
Very
does that
different.
work? Yes.
Yeah. So fiance visa is created for people who are engaged to U.S. citizens, okay? Has to be a U.S. citizen who you're engaged to. And it was created to allow the beneficiary, the intending immigrant, to enter the United States for the sole purpose of getting married within 90 days of entry. So that's the purpose of the fiance visa. Now, historically, the fiance visa was a much faster route. It would usually take about a few months or so. You get your visa to enter the United States. And most people, they just want to get here. So fiance visa was very appealing in that way. But I want to say maybe a few years ago, around the time of COVID, the fiance visas became, the processing times became much longer. So now it really doesn't make sense to apply for a fiance visa if you have the ability to just get married and go through the process that way. With marriage, with a fiance visa, once you enter the United States and get married, there are additional documentation that you have to file in order to maintain status here in the United States. Okay, so it's not just enough to get married. That doesn't give you permanent lawful status. You have to then apply for your green card. And that green card process depends heavily on your new spouse. And that new spouse must continue the process for you, must participate in the process for you to continue with your green card. Um, a lot of the times, not a lot of times, but there are situations where people come in on a fiance visa to start their new lives together, and they experience something that they never thought that they would. They're thinking a happy marriage, happy life. They go through with their green card with no issues, but sometimes that's not the way that things don't work out. You don't get married, which then creates a huge immigration obstacle for you that you may not be able to overcome. And so that's the dangerous part about a fiance visa. Or you might get married, but the spouse isn't willing to proceed with your green card process. And so there's just a lot of red taping with the fiance visa, because if you come in on a fiance visa, you have to receive your green card through marriage to that US citizen.
That person.
That person. So if that person decides it's over, you're kind of stuck in a very limited and a very difficult situation. So I typically advise against fiance visas because of all the red taping. I advise, if you're able to get married, get married. But there are situations where it's going to be more difficult to get married first. And so the fiance visa makes sense. Like, there are some countries that, let's say, like, there's same-sex marriages that do not allow same-sex marriages. So you cannot get married outside of the United States. You have to get married in the United States, depending on the situation. Or there may be a situation where just getting the right documentation for the marriage is just very difficult or impossible according to the requirements of that particular country. And so getting married here in the United States is easier. So, in those types of situations, the fiance visa makes sense.
Thank you. I know in certain cases, even when the marriage breaks down, talk about if there is like domestic violence involved, what laws are there to protect this victim?
Yes. Okay, so in the Violence Against Women Act, there are provisions specifically made for immigrant victims of domestic violence. And that is an area that I am passionate about. During law school, I took an internship where I assisted victims of domestic violence to obtain protective orders against their abuser. And we received training on how to identify domestic violence and how to assist. So when I went into practice, I tried to merge that experience and knowledge and education with the knowledge and education that I had about immigration law. And so I actually work with a lot of victims of domestic violence in the immigration context. We have people who, men, women, and children, can obtain their green cards without their abuser's help through this particular statute. So we help people to do that. There's a lot of misconception about VAWA. VAWA is what we call the Violence Against Women Act for short. There's a lot of misconceptions about it. Many people kind of rule it out and say, oh, I don't qualify for that, because they think that they have a limited idea of what domestic violence is. And they think that immigration will only identify physical violence as domestic violence, and that is not true. Immigration actually, fortunately, defines domestic violence very broadly. So it includes not just physical, but emotional, financial even, which is something that's overlooked a lot. But it's one of the most common ways that abusers keep their victims trapped in relationships. Mental abuse, verbal abuse, sexual abuse, all of that is encompassed in the definition of domestic violence. So we have situations, and immigrants experience domestic violence a lot differently, okay? Because they're kind of they have a vulnerability that US citizens do not have. They have the vulnerability where they're actually depending on their abuser oftentimes for their ability to work or to remain in the United States with their children, or to maintain their life here. And that leaves them in a very vulnerable position. So we help immigrants to identify if they are being victimized, and then we help them to kind of gain their life back by applying for status, lawful status in the United States under the Violence Against Women Act. One of the most common questions I get also about VAWA is, will my abuser get in trouble? Because although they are being victimized, oftentimes victims don't want to hurt their abusers, and they want to make sure that their abusive spouse, parent, or child is not going to be affected by the petition. And I think it's important for people to know that they're not affected by this petition. There are different avenues that you would go through. If you are looking, there's a criminal side of things, which is completely different from immigration. So if you want to get criminal, proceedings involved, you have to get the state involved for that, right? But immigration is federal, and this application was created to provide safety to the victim, not to prosecute the abuser. So there are actually no consequences at all for the abuser if you file an immigration petition. But sometimes we have to get other things involved, like maybe they still need a protective order. So we have to get the court involved to get the protective order. Or sometimes there are criminal proceedings that need to be filed, and that's done separately if that's what needs to be done.
My question is, if there are children involved who are also victims, are you as an attorney mandatory reporter in that case? Like as a nurse, I would have, that's mandatory reporting for me when stuff like that happens. How is it for you?
So we have attorney-client privilege, and everything has to remain secret. It has to remain confidential between me and the client. And I do not know of a requirement of a mandatory requirement to report if children are involved. But most of the time, I don't think I've ever dealt with a child who has been abused. So maybe because I've never come across it, but most of the victims that I help are men who are victims, and women who are victims of domestic violence.
Okay. Thank you. Well, as a strong advocate myself for sexual assault, domestic violence, and homelessness, I'm very happy to hear that this avenue is there to help victims. So, can you tell us a little bit about someone who has been ordered removed from the United States for whatever reason? They may not have been here illegally, or they overstayed their visa or something. What recourse do they have?
Yes. So this area can get very complicated, and it's going to be a lot of times based on a case-by-case basis. So I won't get into the technicality of everything. But at the moment, if you have a removal order, it is a great time to seek legal assistance, because there's something called prosecutorial discretion, where that is being granted actually pretty generously, where we will ask the government to pretty much dismiss the case based on several positive equities that the person may have. So I've had recently 2 removal orders I had one actually dismissed recently that had been in place for 20 years. He was removed very young, ordered removed very young in his life, and he had never done anything about the removal order. He was married actually for 10 years and to a U.S. citizen. But, the removal order creates an obstacle. Even if you're married to a U.S. citizen, it creates an obstacle from you to be able to move on with your green card. And so it created this obstacle where he could not move forward with his green card. And the solution was to remove the removal order. And the only way that we were able to do that was to pretty much use this prosecutorial discretion process by asking the government to join our motion to dismiss this removal order. Once it is dismissed, or you could reopen and do it through the court, or you can dismiss it and do it through USCIS. Once it's dismissed, then we can file the paperwork with USCIS the normal way and proceed. And so we're in the process of doing that now for him. So yes, to answer your question, if you have a removal order, it doesn't always mean that that's the end of the road for you. There are other steps you can take. Prosecutorial discretion had kind of gone out the window when the Trump administration was in place. So it was not available. It was very stringent, very strict rules applied to people with removal orders. And now that's changed. So people should take advantage of it if they can.
And I'm sure it depends on why they were ordered removed, right?
That's going to play a role. But yeah, it is going to play a role because what they're doing is they're basically balancing negative equities with positive. So if you have like committed, very serious crimes that led to your removal, it might be harder, but depending on different things, like maybe the crimes happened many, many years ago, and it's clear that you have been rehabilitated, you're a changed person, you have a new life, you've done great things in the community, you pay your taxes. Maybe there's someone in your family who's a US citizen or permanent resident that is very ill that you help to take care of. Maybe you volunteer and, different things in your life that can show that the government should use their discretion to allow you to move forward with your green card.
Great information. Thank you so much. Anything else that you want to share with our listeners?
No, well, like I said earlier, this is a great time for anybody who wants to file an immigration application to do so. Because like I said, if you have removal orders, you can possibly ask for prosecutorial discretion to get that dismissed, to move forward with your green card. If you're getting a green card through marriage, they're waiving interviews now. So
yes, exploring that. I saw that somewhere.
yeah. So now they are actually waiving interviews for people who are filing for green cards based on marriage. So you no longer have to attend an interview with your spouse. And a lot of people are grateful for that because that process is very intimidating and scary. And, it's so uncertain of what will happen. So what's happening now is you're going to submit your application with all the supporting documentation, and the government will actually make their decision on whether to approve your green card based on the documents that you submit without scheduling an interview.
Wow.
So not only does that, prevent you from having to attend an interview, but it also helps to kind of speed things up. And I think that's why they're doing it, is because there's just such a backlog. Like I mentioned earlier, everything is so inconsistent with the processing times. I mean, literally, you can file your green card application and be waiting a few months for a decision, and some are waiting like more than a year for a decision. So it's just so inconsistent. But by waiving the interviews, now you don't have to wait for your interview to be scheduled and attend the interview and then wait for a decision afterwards. So that means they're processing faster.
Yeah, awesome. And I'm sure that relieves a lot of anxiety because I remember how, the palpitation some of the spouses have, because they're like, oh my gosh, I'm gonna get turned down. And oh.
Yeah.
So tell our audience where they can reach you.
Yes, you can reach me by calling me at 321-325-1125. Again, that's 321-325-1125. You can also contact me on my website at www.sapeterkinlaw.com. And I'm also all over social media. I'm on Facebook, I'm on Instagram, I'm even on TikTok.
She's on TikTok. I follow you all the time, and I listen to your tips and your little funny videos all the time. Thank you
Yeah.
so much for being here. It's just great information. I don't know if there's any last thoughts.
No, I just want to say thank you again for thinking of me and inviting me onto this platform.
We're very happy to have you, and thank you so much for sharing with us today. That's it for today, listeners. From Stuck to Limitless. See you next time. Tune in on Saturdays, 3 p.m. Eastern Standard Time to WJIL.today. Have a great day. Until next time, for another episode of From Stuck to Limitless. I'm your host, Marie McKenna.